The next case to come before the court this morning is Katherine Todaro versus Jacob Schrock. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time for rebuttal, if you would let me know when you get started. I'm keeping the clock this morning. Please don't use the names of any minors or victims who are not already named as parties. We are live streaming this oral argument and posting it on YouTube. The court has read the briefs. We are ready to proceed when you are.
Thank you, Your Honor. May it please the court, my name is James Armstrong, and I represent the appellant in this matter, Jacob Schrock, and if I could reserve 3 minutes for any rebuttal, Your Honor. Your Honors, if obviously you've read the brief, the real main concern as to what happened in the trial court is procedural in nature. It is the refusal to allow a transcript to be submitted and objections to be supplemented based on that transcript in a matter involving a civil stalking protection order. Civil stalking protection orders are very fact specific. It requires certain elements to be met. The matter was heard before a magistrate. That allows a disagreement with the magistrate to be heard by the trial judge. After an objection was timely filed. A request for a precipice for the transcript was requested at the same time. A mention that the objections would be supplemented once the transcript was completed, and the trial court never allowed that to happen. This has not happened in my research too often, in which a court has refused to allow somebody to supplement the objection. When it has happened in the 8th District, the neighboring court said where a trial court adopts a magistrate's decision and the objection to the factual finding before the objection party files a timely requested transcript or materials necessary to complete the independent review, it's an abuse of discretion that takes place. The other neighboring district to us, the 11th, made a similar ruling in 2015, stating the obvious fact that specific questions specific questions to specific objections require a transcript to draft a proper objection. In this case, it's not like some of the other matters in which I know that this court has ruled upon where somebody had filed an objection but never requested the transcript, or requested the transcript and never supplemented it. Here, the person never even got an opportunity to supplement the objection. In my brief, I wanted to focus first on the fact that there were grounds to object and then talk about the procedural issue, because the one thing I think the appellee and I agree on is the court mainly needs to deal with this procedural issue, because that's the long-lasting statewide implication of this case. If a trial judge is able to arbitrarily say, you don't need the transcript to file an objection, then Civil Rule 53 and all our appellate procedures kind of go out the window. In fact, in a case that came out just days after the magistrate's decision, EV versus RV, on paragraph 12, this court specifically said objections based upon evidence of record must be supported by a transcript of the evidence submitted to the magistrate or an affidavit of the evidence if a transcript is unavailable, quoting Civil Rule 65. I don't understand the trial courts not allowing a person to supplement, especially when you're talking a civil protection order involving a next door neighbor. And it was a complete violation of due process. And again, I think the main concern here is the denial of procedural due process is certainly the main concern, and to fail to follow proper procedure can never have a legitimate result. And thus we find ourselves here on appeal that may or may not have even been necessary had the trial court simply allowed my client, who was represented by somebody else at the trial court level, but had that opportunity to object to the magistrate's decisions and findings, because there was some disputed testimony regarding what happened and when. That is the main issue in this matter, is that procedural issue. There is concerns that the trial court allowed to stand a civil stalking protection order when the elements weren't met. It is concerning that a person who initiated and instigated the issues in the first place was able to run to the court and get a civil stalking protection order. It is concerning that the neighbor who was the people who actually did evidence indicating that it changed their lives were actually the people being accused, in which they do a privacy fence to protect their little Yorkie. They have to put up blinds in their house, and the young child who my client was supposedly, and I don't even understand the situation where they claim that he was romantically interested or whatnot, was already a victim of sexual assault. And she apparently, this triggered her losing sleep based on the statements made by the petitioner. This is again, a very troubling case. It's troubling primarily because of the procedural due process that was not granted to Mr. Schrock. And it's a matter that I think needs to be, I asked the court to address, reverse this matter. And I believe since it's a procedural matter, this matter would probably need to be reversed and remanded back to the trial court to properly address the objections to the decision. Again, I point out throughout my brief the numerous problems in granting the civil stalking protection order, based in fact primarily on the court's case that came out while this case was still pending. I don't know how much time I've used up as of right now, but
You have a little over 8 minutes remaining.
Okay, well, I talked too fast then.
Mr. Armstrong, I have a couple of questions. I hope you can help clarify some things for me on the timing of this. So the transcript was actually filed eventually, right, with the trial court?
It was on the 14th of December of 2020, if I remember the docket correctly.
Okay, and then thereafter, did Mr. Schrock file any additional objections?
After the transcript was filed?
Yeah.
No, the trial court up and dismissed it 8 days later, which I think was less. I think if I remember my calendar right, the 14th would have been like a Monday, and that was right during around Christmas. So, and it was dismissed the Tuesday before Christmas. So the transcript would have been already probably sometime on the 14th, maybe not even to the 15th. So we're talking not even 2 weeks. We're talking 8 days, not even business days, 8 days, and the court up and dismissed it. And if you look at the trial court's statement, they essentially said that you didn't need the transcript to do a specific objection, which I don't know how you can make that statement when you have a fact specific case that are necessary in protection orders. It just kind of baffles me for that statement. Well, I don't want to further comment on that. I didn't even understand the statement from a logical point of view, let alone all the case law.
Mr. Armstrong, I have a question, but I appear to be having a little bit of internet trouble. I freeze, just let me know. And I don't want to make that bad commercial that's on TV with people freezing. You referenced Civil Rule 53, and I believe the trial court used Civil Rule 53 in its order. Would you agree with that?
I would. I wouldn't say they applied it properly.
Well, but Civil Rule 53 uses the word specificity, doesn't it?
Well, Your Honor, it does use the word specificity, but the rules also allow you to supplement it.
Okay. Is Civil Rule 53 the right rule? The right, I guess what I'm saying is, what's the purpose of Civil Rule 65, which is titled Civil Protection Order then?
Well, I think 65 is the more specific rule. and it's the one that
Okay.
was cited by this case, or by
Then-
this court.
If I look
focused on
under
fa-
65, and I'm sorry, I didn't mean to interrupt. I'm just skimming it, but I don't see the word specificity
Yeah.
that is in 53.
So,
I
well,
guess what I'm saying is you might have an argument here.
So, well, I appreciate that, Your Honor, but I also know that even if you use Civil Rule 53, as it's been properly interpreted, is that fact-specific matters require a transcript. The appellate rules require a transcript. I mean, you have to request that. It's even in your docketing statement about the transcript and how you're going to do that. So for a trial court to not even allow a transcript, and then you get into the point, Judge Callahan, where the trial judge is obligated in an objection to even do an independent review. Well, if there's nothing in your order indicating you even did an independent review in the regard of looking at the transcript, knowing that the objection was filed, then all the rules are rendered meaningless if you could simply just say, well, it wasn't subjectively specific enough for me.
Well, let me play devil's advocate here for you since you have some time. A fact-specific objection, correct, but does a legal objection require a transcript? If it's just an objection.
I'm going to try. I think I understand the question, and and it's that you could have, if it's solely a legal argument, if the facts are undisputed, I wouldn't disagree. In a case in which you have elements, and in this case you have elements that have to be reached to have a protection order granted, you have both a mixture of law and facts that you must apply. And if you don't have the facts pursuant to the transcript, then how do you properly apply the law?
Did the motion indicating that there was going to be an objection, did it indicate whether there was an objection to the legal conclusion or factual conclusions or both, or was it silent on those issues?
I believe that what it simply stated that it was, it stated that I objected to the magistrate's decision, and the more specific objections will be supplemented once the transcript is prepared. One of the things I point out in my brief is that the way the trial court interpreted this is more stringent than if it would have been a bench trial. If it were a bench trial, you request the transcript and you have an automatic appeal to, in the case of Wayne County, to the 9th District, at which time you have the opportunity to have the transcript and file assignments in error based on the transcript. Here we have a situation where we have a trial judge who says, you don't need the transcript to file the objections. I'm overruling them because they weren't specific. So we actually have a situation where you're better off objecting to even having a magistrate hear the case, go to the trial court, because then you at least have due process that you're allowed to have the transcript before you articulate your assignments of error. Based on, if we allow this to stand, you have a trial judge who can just sua sponte and subjectively say, you don't need the transcript.
And counsel, I need to let you know that you have approximately 2.5 minutes remaining.
Okay, well, if I may, I'd like to reserve that 2.5 minutes.
Thank you.
Thank you.
Counsel for Mr. Schrock.
Yes, good morning, Your Honors, and may it please the court. My name is Michael Beitendijk. I represent the appellee, Ms. Todaro, in this matter. And I'd like to start out by saying I think the only issue which should be before this court is whether the overruling of the appellant's objections on December 22nd was within the discretion of the court. Now, obviously, I don't have the judge here, but I think just going to the heart of the matter when he says you don't need the objections to file the or you don't need the transcript to file the objections goes to the heart. And I think when he was applying Rule 53, where it talks about the specificity, is that he was saying that you could go off of the decision by the magistrate, which was then subsequently reviewed by the trial court, to at least craft some of the objections that you may have with the magistrate's decision. Now, obviously, under the rules then subsequently, you can either file a request to supplement it once the transcript has been provided, which cases have said. And the other option that the appellant could have availed himself with was to file a request for the extension of time. Nothing was done. They just filed, we object, and we'll supplement our objections. And then the trial court ultimately dismissed the objections. Permitting the appellant to go forward with his assignments of error, he talks about due process with regard to this should be the only matter, you know, that would deny my client due process for not being able to, you know, articulate these objections in the lower court. So at best, yes, you know, the appellant's appeal either should be dismissed or the matter should be remanded back to the trial court, although we are prepared to argue the assignments of error that was provided by the appellant. And we feel that if you look at the transcript, which this court has acknowledged as being filed, there was ample evidence to support the findings of the trial court. And the appellant filed, and it was not present counsel, a motion to dismiss with the attaching just, we, you know, moved to dismiss based on that recent case that he referred to. I think it's EV versus RV. And, you know, the trial court, when with that request for dismissal, said that that case didn't even apply. And it keeps getting, it got resurrected here in the appeal by the appellant. And if you look at the case, it just said that where email or text which don't have an actual threat, you know, do not rise to the level of justifying a civil protection order. Here, there were direct contact by the appellant with my client. There were threats made towards her, some using some very graphic language. There was testimony that he told a police officer that, you know, if the dog came over to his yard, he was going to put a bullet in its head. He's yelled and threatened one of the children of the appellee, and he started to cross the line before this fence was put up, and was making threats and to the appellee's father during a family barbecue celebrating a birthday party. So not only were there actual direct threats, there were also additional threats by text as well. But there was certainly a continued course of conduct, all within a short period of time, which meets all the elements under granting a civil protection order. And my client, the appellee, Ms. Todaro, certainly had every right to be fearful for herself and her family, and the court found as such.
So could I go back to the procedural issue for a minute
Yes,
here?
Your Honor.
I'm going to basically ask you the same question I asked Mr. Armstrong. What rule applies here, 53 or 65?
Boy, I've looked at the cases, and there at times seem to be a blending of the two, but definitely 65 is specific to the civil protection orders. But looking at the case law, it seems that it's been kind of a melding of the two.
Thank you.
And, I guess I'm going to conclude, and I'll let Mr. Armstrong have rebuttal. But, I do not believe the court abused its discretion. There were ample other opportunities under the rules, whatever rules you want to apply, to have either requested to supplement the transcript. They could have, prior to the transcript being provided, attached affidavits which regard to factual matters, and the appellant could have requested an extension of time to file the objections. So, and I think it's taken out of context when he said a transcript wasn't necessary to file the objections, because the court, I think if you look at everything, clearly is referencing that the objections hadn't been filed with any specificity, and as a result, he was just saying you could go off of off the rather detailed decision by the magistrate to craft specific objections that you may have, and then supplement it once the transcript was provided. So thank you, Your Honors. I appreciate your time.
Thank you, counsel. Counsel for the appellant, you have 2.5 minutes for rebuttal.
Thank you, Your Honor. May it please the court. I appreciate my honorable opposing counsel showing the discrepancies in the transcript with regard to the testimony, indicating why a transcript was necessary for the trial court to address the objections properly. One, there were no real physical threats. The only actual threat was when he said he was going to sue her. And I would concur with my opposing counsel that the language was somewhat colorful at times. The other thing is interesting is when my opposing counsel talks about the threatening to shoot the dog. The black lab kept coming after my client's family's Yorkie, which was a pint-sized dog, to the point where one of the witnesses testified that Mr. Schrock had to hold the Yorkie above his head while the black lab was on him. So, and to the point where they ended up calling the dog warden because counsel's client kept letting that dog come onto their property and cause mischief. So it's somewhat interesting that that's one of the things that they cite, and it's also one of the reasons why I, near the end of my brief, I cite the old equity principle of clean hands when coming to court to ask for a shield, when in reality what you've been doing is using a sword the entire time towards your new neighbors. With regard to the procedural matter, once again, neither in his brief nor here did I hear any case law that supports the proposition that a trial judge can simply arbitrarily overrule an objection, knowing that a transcript's been filed, knowing that the objecting party has requested the opportunity to supplement, and that has not been, I haven't found any situation where such a scenario has been allowed.
Mr. Armstrong, on that point of timing to supplement after the transcript has been filed, what is your understanding of the time frame that the appellant had to file that?
I think a minimum of at least 2 weeks from the date the transcript was filed. You usually have 2 weeks in which to object. Typically, I always work on the rule of thumb, and the local rules change from court to court, of the 14 days. I do a lot of work in juvenile court, and I believe the local summit juvenile rule is 14 days. And if I can't do it in 14 days, then I do ask for the extension to do that and to protect my clients' rights. And here, we didn't even come close to that, Your Honor. We didn't have 8 days, and a motion to set aside a magistrate's decision is 10 days. So we're 2 days less than even a motion to set aside, which isn't even a final appealable order.
Is there a local rule that is on point in Wayne County for this issue? Is it 10 days?
I don't believe there is a specific rule with regard to that I know of, Your Honor. I'm just kind of going generally speaking. That's a good question, and I apologize for not looking more closely into that.
Thank you. That's okay. Thank you.
And thank you, counsel. Thank you both, actually, for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Our next video oral argument is scheduled for Tuesday, September 21st. We are adjourned. Have a wonderful day, counsel.
Thank you, Your Honor.